I'm Caroline Acton. I'm an employment solicitor from Consilia Legal. So I'm going to try and update you and give you some information about shared parental leave over the next sort of half an hour, 45 minutes. Before I start, I just wanted to do a quick poll with you all to see if anyone has received any requests yet for shared parental leave. If you have, can you put into the chat box whether you have and also how you've dealt with them? So it'd just be quite interesting to hear from you all to see whether you have had any requests yet and how you've been processing and dealing with those to date. So as I said, I'm going to try and do an overview for you. I think you might all appreciate it's quite a complex and detailed area and change to the law, so it's something we all need to get a grasp of and try and understand. One of the sort of tips I would say is it may be worthwhile downloading the ACAS guidance on shared parental leave, as this does clearly set out quite a good information package about how the process works. And I think it is really key to try and understand for yourselves what actually happens on the process, how the notification works, and how the booking leave works. And if you get a proper grasp of it, it should help them with any requests going forward. Okay then, so summary of the webinar today. So this is basically what we're going to look to cover. What is shared parental leave? What happens with maternity, paternity and adoption leave? We'll cover eligibility, what happens with the pay, and we'll have a look at the process and steps for employers. Okay, on the chat we've had a few people coming in to say they've had a request and people are working on policies. Somebody else, Tara, has said they're currently writing the standard within the ACAS guide. I'll talk about this at the end for steps for employers about putting a policy in place, and I think it's a great recommendation to have a policy in place as it helps you and the employee really understand what's going on, but I'll talk a bit more about that at the end. Right, so having a look first of all at what shared parental leave is. So it is a brand new legal entitlement that did come into place at the end of last year, so the 1st of December 2014. Now it doesn't apply until the babies are due or placed for adoption on or after the 5th of April 2015. So that's probably why you are now starting to get requests, because it's becoming a lot more imminent, is this. Now, the sort of concept for shared parental leave is it's an opportunity for parents to be flexible with the leave and also share caring arrangements. So in a nutshell, what it basically does is it enables parents to share the caring responsibilities evenly, or have one parent taking the main caring role, depending on their preferences. And the sort of key thing with shared parental leave is, unlike maternity and adoption leave, eligible employees can stop and start the shared parental leave and return to work between periods of leave. So as you all know, with maternity leave, there's the sort of keeping in touch days, but that's it. Once an employee returns from maternity leave, it's game over. They're back at work. They can't then go back on leave. The shared parental leave allows this proper flexibility where they can come back maybe for a month and then book another period of leave. So it may assist some parents and some employees. With shared parental leave, it can only be used, though, once the mother has already returned to work or given notice to their employer that they wish to reduce their maternity or adoption leave, and confirming when that will come to an end. So that's quite key, that shared parental leave can only be used on those two occasions. So with the latter occasions, where they're given notice to their employer that they wish to bring it to an end and confirm when they want to do so, this means that their partner could begin to take shared parental leave whilst the mother is still on maternity leave or adoption leave. So it's something to be aware of. The other thing as well with shared parental leave is it must be taken during the child's first year, so the first year following the birth or the first year of adoption placement. So it's got to be used within that year. So how is it calculated then? So it's calculated using the mother's entitlement to maternity and adoption leave. So under maternity and adoption leave, they have 52 weeks. They have 52 weeks leave, and like I said, they can reduce their maternity or adoption leave entitlement, and then their partner can opt in to take the shared parental leave and take the remaining weeks as shared parental leave. So it's based on those 52 weeks. And like I said at the start, the sort of main key of this is that employees can stop and start shared parental leave and also return to work during periods of leave. So it does provide for that real flexibility. So for an example, a mother could take 6 months maternity leave, prior to that give notice that she wishes the maternity leave to come to an end at the end of the 6 months, return to work for a month, and then take 3 months shared parental leave. So it really does allow for a proper flexibility there. Just have a look through, see if we've had any questions. Someone's asked if we'd like to know if someone on shared parental leave can claim sick. Be put onto sick pay and then take the shared parental leave at the end of their absence. Well, you're either on shared parental leave or you're on sickness absence would be my response to that. So if they've opted for shared parental leave, unless they withdraw it under the notification procedure and then they're effectively on sickness absence after that, then that might be one option. But if they're on shared parental leave and then sick, I think it'd be a discussion for the company as to whether they agree to postpone the shared parental leave so they can take it at a later date and then they're effectively on sick leave. So I think it has to be a discussion between you and the employee as to which one you do. But you'd either be absent on sick leave or absent because of shared parental leave. I've got another question. Please can you confirm what arrangements are in place in relation to the ending of a fixed term contract? Yeah, I might come back to that one at the end, Paul. I'll just keep a note of that and come back to that one for you. Right, we'll move on to the next slide then. Right, so basically with shared parental leave, just another overview of what type of leave can be booked under the process. You've got two types. You've got this continuous leave and discontinuous leave. Continuous leave is, as you would expect, a period of leave that is taken in one block. So a block of 4 weeks, a block of 2 months. And with this type of leave, it cannot be refused by an employer. So if an employee submits a request for continuous leave, which we will discuss later how they go about the notifications, that has to be granted. And unfortunately, the employer will just have to work around that. Discontinuous leave, however, this does allow for a bit more flexibility for the employer. So this is where a period of leave is arranged around weeks where the employer will return to work. For instance, they'll want to work every other week for a period of 3 months, have a week on, week off type arrangement, or work for a month, have a month off. And they do require the employer's agreement for this. So that does allow a bit more flexibility for you. Shared parental leave must be taken in complete weeks, but it can start on any day of the week. So just bear that one in mind as well. Okay then, so maternity, paternity and adoption leave. So in essence, this just continues and remains as it always had done. So nothing really changes with that. So under maternity leave, a mother gets 52 weeks leave, and if they qualify for pay, 39 weeks paid leave, 13 weeks unpaid. And same with adoption, 52 weeks leave. So that just continues, but as I said at the start, if the mother or the adopter wishes to reduce their maternity or adoption leave, they can do so and then opt into the shared parental leave. So it's all based around 52 weeks, and the amount of shared parental leave that's left over depends on how much maternity leave or adoption leave the mother has taken. With paternity leave, fathers will get 2 weeks ordinary paternity leave. There was a right for additional paternity leave, which was introduced back in 2011, which worked on the basis that if the mother wanted to come back to work before the end of a maternity leave, the father could then take additional paternity leave. I don't think this was really used that much because it required the mum to basically give up the leave and just come back. There was no flexibility as there is with this shared parental leave. But in essence, additional paternity leave will no longer be available for babies due on or after the 5th of April 2015. So it's this new shared parental leave that you have to concentrate on now. And the key thing you have to be aware of, though, is the birth mother and the adopter must take at least 2 weeks maternity leave following the birth of a child. So they can't get out of that 2 weeks compulsory maternity leave. For factory workers, it's 4 weeks. So if it's manual work in a factory, then they have to take 4 weeks leave. So that's just something to be aware of there. Right, okay then, so moving on to eligibility. So to qualify for shared parental leave, the mother must have a partner. They must be entitled to either maternity or adoption leave, or statutory maternity pay or statutory adoption pay, or maternity allowance. For statutory maternity pay or statutory adoption pay, they have to be employed for 26 weeks by the 15th week before the expected week of childbirth. and have earnings not lower than the lower earnings limit, which is currently £111. And the maternity allowance is payable more for people who don't qualify for statutory maternity pay, such as self-employed people. And they also must give notice to reduce their maternity and adoption leave or reduce their pay. Now, in order to give the notice, what they have to do is put this in writing, and they must state the date that they want their maternity leave or adoption leave to end, and this must be at least one day after the compulsory maternity leave or adoption leave period. It must be one day after that 2-week compulsory period. So they must, by law, always have that 2 weeks off. And it must be given 8 weeks after the date. The request for it to end must be 8 weeks after the date they give the notice. So it has to be in writing, has to state the date they want it to end, and the period for it to end must be 8 weeks after the date they give the notice to their employer. And then basically once they've submitted that notice, it can't be withdrawn unless it's in very, very limited circumstances. So really it's quite a binding notice. It's quite a big decision for a mother to make as to whether they want to bring to an end the maternity leave or the adoption leave or cut the pay. And if they do decide to do that, then they're sort of stuck with it unless neither the mother or the partner are entitled to shared parental leave or shared parental pay. The mother who served the leave to cut shorter notice did so before the child's birth. So if it was done before the child's birth, she could revoke it, or the partner dies. So it's very limited circumstances in which she could revoke that notice. So once she's given notice to her employer to bring to an end the maternity leave or adoption leave, it's kind of stuck there. So that's just something to bear in mind. Moving more on to eligibility, because there's a bit more on this. We need to look at when parents intend to take shared parental leave. What you need to be aware of as well with this is that sometimes only one parent in a couple is eligible for shared parental leave. So this means that they can't share the leave between them, but they will still be eligible to book it. So even if only one parent is eligible for it, they can still use that shared parental leave. Right, so moving on to parents who intend to take shared parental leave. So parents who intend to take shared parental leave, so they must be an employee. So this is why sometimes one parent might not always qualify because they may be self-employed. They must share the primary responsibility for the child with the other parent at the time of the birth or adoption placement, and have notified their employer of their entitlement and provided full information. Now I'm going to look at that a bit later on when I look at notification, but this is something to be thinking about. So I've just had another question come in. It says, can the mother's partner be a female partner, i.e. does it have to be a male partner? That's a really good question. I think I was going to talk about that in a bit, but it's good to answer it now. Thanks, Jill. So the partner is the child's biological father or the partner of the mother or adopter. So this can be a spouse or civil partner, or it can be a partner who is living in an enduring relationship with the mother and the child. So it's either the biological father or the partner of the mother or the adopter, so spouse, civil partner, or somebody who's living in a sort of long-term relationship or just living with them and in a relationship with the mother and the child. So it covers quite a wide spectrum there, so you just need to be aware of that. So when you look at eligibility, the parents intending to take shared parental leave must comply with all this, and then on the next slide, they must also satisfy these conditions. So a parent wanting to take shared parental leave must satisfy the continuity of employment test. Now this is a little bit complicated. So it means I've tried to put this on the slide to give you a bit of the information. So basically must have worked for the same employer for at least 26 weeks at the end of the 15th week before the due date or adoption placement, and they must still be working for the same employer at the start of each leave period. So that's something to get your head around. And in addition to that, their partner must meet the employment and earnings test. So in the 66 weeks leading up to the expected due date or matching date, worked for at least 26 weeks and earned on average at least £30, which is currently in 2015, so £30 a week in any 13 weeks period. And so this is where you can get employed, self-employed or agency workers falling within that sort of qualifying status. So that's something to sort of work on and get your head around and diarise those dates. Now the problem is that parents will have, if both parents are employees and both meet the qualifying requirements, there'll be a joint entitlement, and they'll have to determine between themselves who has what leave when, and if the mother wants to cut short her maternity leave, what they do with that. So that's something for parents to obviously think about and then notify employers. So the last bit of that, I've said what happens if only one parent is eligible. So this is often the case, particularly nowadays. One parent may be self-employed, so they won't be entitled to shared parental leave themselves because they're not an employee, but they may still pass the employment and earnings test, so that test where in the 66 weeks leading up to the expected due date, they've worked for 26 weeks and earned at least £30 a week in any 13 weeks. And so they'll pass that, so then if their partner is an employee, they will still qualify for shared parental leave. So if you've got a couple, one person's self-employed, one person's an employee, that employee may still qualify for shared parental leave as long as their partner meets the employment and earnings test, which is relatively quite low, so I think most people probably would meet that. So that's the eligibility criteria. Has anybody got any questions at all on that before I move on, or is everybody still trying to get their heads around it like I am? I'll just hang on a minute to see if anybody's got any particular questions. If not, I can always come back to them at the end. I think we're all right for the moment, but just keep on typing away if you've got a question. Right. Right, thanks Sally, you've asked the question, when does the partner have to declare their entitlement? I'm going to come on to a slide about notification and things like that, so hopefully I'll address your question then, but if I don't, just shout and type in the box and shout at me. Right, next point then we're going to have a look at is shared parental pay. So I'm just quickly going to cover this. So the sort of rule with this is if the mother gives notice to reduce their entitlement to maternity pay, then the remaining weeks could be taken as shared parental pay. So under the sort of current legislation, I talked before, they get 39 weeks pay under the maternity leave legislation if they qualify, and then if they give notice to reduce their entitlement, those remaining weeks could be taken as shared parental pay. Now to qualify for this, for shared parental pay, those two tests are key again that we just talked about. The employee must meet the continuity of employment test and their partner must meet the employment and earnings test. So we just flick back to that other slide that we discussed. These two tests on there, that continuity of employment test and employment and earnings test, are also relevant for the shared parental pay. So just bear both of those in mind, they're both relevant. And then in addition, for the shared parental pay, the employee must have earned above the lower earnings limit, which is currently £111, in the 8 weeks leading up to and including the 15 weeks before the due date, and still be employed by the same employer at the start of the first period of shared parental pay. So another sort of concept to get your mind around. Shared parental pay is the same as statutory maternity pay, so it's currently it's £138.18 a week, but that tends to rise year on year. Except with shared parental pay, for the first 6 weeks, it isn't calculated at 90% like statutory maternity pay is. So that's often something that mothers may want to take into account. If they only get the statutory minimum, they would probably want to have that 6 weeks at 90% before they look to cut any pay or any leave. And equally, if a mother is entitled to enhanced maternity pay or adoption pay under policies at her work, she'll probably want to exhaust that before giving up any right to pay or leave, and giving notice to bring that to an end, because otherwise you're just moving on to this £138.18. It's something that parents are going to have to sort of sit down and work out what they want to do. Again, with shared parental pay, as with shared parental leave, if both parents qualify for it, they will have to decide who will receive it and how it will be divided between them, and inform their employer of their proposal, which we'll talk about in a bit. So it's that in itself, again, if both parents do qualify, then it's something they're going to have to think about who gets what and how much and when. So something to have a think about. We've just got a couple of questions in. Thanks, Mark. So if the partner is not working in any capacity, should be refused once requested. Yes, if they don't qualify, if they don't qualify for shared parental leave, then as I understand it, then yeah, it should just be refused because they don't qualify for it. I think the problem is, like with any new legislation, is everybody's just trying to sort of get through sort of paperwork on it and try and understand it. But that's how I understand the position to be at the moment. You have to qualify and be eligible, and if you're not, you're just simply not. So that would be the case. Thanks, Emma. We've got a question about bank worker who is on a bank agreement with the company but not obliged to accept a work shift. If they meet the employment and earnings test, should be able to request. Yes, I mean, arguably, if they meet that, if they meet that test, if we go back to that eligibility thing, so if they are, I mean, they're a bank worker, so whether they're classed as a worker or an employee, but if they are an employee and they share the responsibility for the child with the other parent, have notified of entitlement, and then they meet that test of continuity of employment, so they've worked for at least 26 weeks and they could qualify. The employment and earnings test is for the partner, so if the bank worker doesn't qualify, it could be that their partner qualifies for it, which won't really impact on you. And then Flora, thank you. If a manager refuses a discontinued period of leave, the employee can withdraw, that's right, and then out in 3 notices the periods they wanted to, in the first place, put, as long as they give the notice. What is Okay, so you mean if they refuse discontinuous leave, they can put another request in? Yes, they can keep on putting another request in, but they only get 3 chances to put a request in. So it's 3 chances per employee who qualify for shared parental leave. They can make 3 requests for booking leave. And if there's a genuine reason why you can't accommodate that discontinuous leave, then as long as you apply that criteria consistently amongst all your employees and you act fairly, so you're not discriminating or anything like that, then it can be seen as genuine. I think, unfortunately, with this, it'll be a case of let's see what happens as this matter pans out and people do make more requests, and we'll see how we get on with that. Okay, then. So the process, right? So first of all, this is just a thing for, sorry, I think we're on the wrong side of this. Sorry about this, everybody. No, go back. Oh, I think I'm missing a slide. Is SPL suitable? Sorry, I'm missing a slide. I did have about, I had another slide that said the process. It said, is shared parental leave suitable, ? And basically I put that in there because it's up to the parents to consider how they'd like to care for their children. So it's obviously a question that parents are going to have with each other as to what they would like to do. And then the next bit of that slide was the notice of entitlement to shared parental leave. So what an employee must provide to their employee if they wish to take shared parental leave is they must provide a notice of entitlement. And this must be provided 8 weeks before they intend to take the shared parental leave. And there's certain things that need to be included in that notice, which is set down in the legislation, or if you look at ACAS, it's on there. But basically, it's got to include how many weeks maternity or adoption leave are to be taken, how much leave both parents are entitled to take, how much leave each parent intends to take, when they expect to take their leave, signature of both parents, and other things like names of the mother and the partner, start and end dates of any statutory maternity or adoption leave, and the child's expected week of childbirth or actual date of birth or date of placement. So there's certain information that must be provided on this notice. And like I say, it must be provided 8 weeks before they intend to take the shared parental leave. And alongside that, the employee must also provide a declaration. This is a signed declaration, and that must contain certain information along the lines of they will be sharing responsibility for the care of the child, the mother has given notice to end her maternity or adoption leave, they meet the continuity of employment test, the information they've given is accurate, and should they cease to be eligible, they will immediately inform their employer. And then coupled with that, alongside that, the partner of the employee must also provide their partner's employer with a signed declaration, and there's certain information that must go on that, but generally it's the name, their name, address, and national insurance number, and other things confirming that they are the father, the mother, or the partner, and confirm that they have sharing responsibility. So there's quite a lot of information that has to be provided. So there's a notice and the declaration to go to the employer 8 weeks before. So you are notified of quite a lot of information 8 weeks beforehand. Oh, we've got it up now. Brilliant. Yeah, we've got it there. So that's the slide. This is the slide I'm talking through at the moment. So it's come up now. So that's So that's something to sort of understand, and it may be worthwhile having a look yourself at the legislation or at the ACAS guidance and making a note of what information should be provided, because then, if the correct information isn't on there, you know straight away. And then finally on that slide, I'm just having a look at what if parents change their minds about how they divvy up shared parental leave. So what if they come to this great agreement, give all the notifications, and then they say, oh, actually, I'd rather do it a bit differently. They can vary it, but both parents must notify each employer details of their original division of leave, advise their wish to change this, and advise how they now intend to take it. And this will count as another notice. So I mentioned earlier that each employee has 3 opportunities to book leave under shared parental leave. And that's it. So they've got 3 opportunities. And if they wish to vary it, it's a new notice. So they lose out on the ability, they've sort of used 2 notices there. But they can do it, but it just counts as another notice. Just going to have a quick look at some of the questions. So thanks, Kate. How would you suggest policing to avoid the use of shared, can't even speak, of the shared leave, i.e. to stop both parents taking leave at the same time more than they're entitled to? I think this is where the notice of entitlement is really key, because all the information you get on this notice should provide you with everything you need to know. So this should confirm how many weeks have already been taken on maternity and adoption leave, so you know how much is left. So, it should even confirm that anyway, but you in yourself will know how much is left, because if, say, 6 months has been taken on maternity leave, there'll only be 6 months left that they can use on shared parental leave. So by being provided with all this information should stop any abuse, because they can't really abuse the process if they give the correct information. And of course, if they don't give the correct information, then they haven't given you the correct notification of their right to take or their entitlement to shared parental leave. So that should be helpful. So shared parental leave, like I said at the beginning, how it sort of works is it can only be used once the mother has returned to work or given notice to her employer that she wishes to reduce her maternity or adoption leave. And that means the partner could begin to take shared parental leave while she's still on maternity leave. So there is a bit of an overlap that could happen there. Okay, I'm just going to move on to the next slide, if that's all right with everybody. Just continue with the process of what happens. So we've had a quick look there at how an employee notifies their employer of their entitlement. And now we're going to have a quick look at how they go about booking the leave. So, I mean, a lot of this might run concurrently. So you might get the notice of entitlement as well as the booking leaves. It might all happen at the same time, but sometimes it doesn't. So it can be booked at the same time or as the notification or later. And again, it's this 8 weeks. The 8 weeks is key. They must, submit this 8 weeks before they intend to take the leave. And the booking leave must be in writing, dated, and it must clearly set out what leave the employee intends to take. So you understand fully what's going on. And then, like I've mentioned already, they're entitled to submit 3 separate notices to book leave. Once you've got that in, now depending on the type of leave that's been requested, you either have to accept this or you can have a chat with them and could potentially refuse it. Now, I mentioned right at the beginning, there's 2 types of leave under shared parental leave. There's this continuous or discontinuous leave, and the continuous leave is where it's in just one block. So it's a period of leave that's taken in one block, i.e. 4 weeks, and this cannot be refused by an employer. Discontinuous leave, this is a period of leave that's arranged around weeks where the employer will return to work, e.g. will work every other week for a period of 3 months. Now with discontinuous leave, this is where you can, legitimately consider it and, may be able to refuse it. Once you get a request in for the booking leave and it's a discontinuous leave request, you should ideally, within 14 days, discuss this with the employee. Now, there isn't really any hard and fast rule here, and under the ACAS guidance, it suggests that you should meet with the employee to discuss it. And I think, in all honesty, that would probably be the best outcome, to sit down with the employee and meet with them. Again, because there's no legal requirement to meet with them, they don't have the right to be accompanied by a work colleague or trade union, but again, you could allow them, and there'll be no harm in doing so, to make it formal but not too formal, so it's something to consider. So you've got 14 days to discuss it with them. So like I say, it'd be beneficial to have a meeting. And then once you've discussed it with them and considered it, there's 4 possible outcomes on the discontinuous leave that you could have. Number 1 is you could unconditionally accept it. So if you're happy with what they've suggested and you can accommodate it and there's no issues, then great, you just confirm. And ideally, you should confirm that in writing within 14 calendar days of receiving the notice. It may be that you can accommodate it with some modifications. The next one is agree with modifications, and you'll discuss those with the employee. And if that's right, then you'll confirm within 14 calendar days of the date you receive the notification, and you just set out what's been agreed. And the third one is you refuse. So you could refuse the leave request, and if you're going to do so, you should do this within 14 calendar days of the date you receive the notice. I mean, obviously, with refusing the leave request, really you should try to give a reason as to why you've done that, and obviously act consistently, as I mentioned earlier. So, if you are trying to accommodate shared parental leave, make sure you're treating people the same. So you're treating females and males the same, so there's no argument on discrimination or anything like that. And, really have a think about whether you can accommodate it, whether you can accommodate it with modifications. But if you genuinely can't accommodate it, and, there is a business reason as to why, then, that's unfortunately is your outcome, and you'd confirm that to the employee. Like I say, you should really do this in writing, and what you should do is set out the options then available to the employee. So the options, if you do refuse, is they could withdraw the request, or you could maybe look to agree a modified arrangement if you can't agree their initial leave request. Now, the one thing you need to be aware of, which is something to get your head around as well, if there's no agreement on the discontinuous leave, then the default provisions could kick in. And this same applies to this fail to respond. So if you fail to respond to an employee on discontinuous leave, it's not good practice, because you should really be talking to them. But if you don't respond, or if you refuse it and the employee doesn't withdraw, then the default provisions kicks in, which means the discontinuous leave automatically defaults to a period of continuous leave in a single block. So this is something I think is going to be very confusing to employers and employees. And I think when requests come in, obviously if it's a continuous leave request, has to be accepted, but you should still chat with your employee and still confirm that so it's clear. Discontinuous leave, really have that discussion with your employee. See if you can accommodate it, see if you can make any changes. If you genuinely can't accommodate it, say that you can't and tell them why, and then say to them, look, they should withdraw it, because if they don't withdraw it, then that discontinuous leave that they put in will default to a period of continuous leave, and they have to just take it. And that can be quite dangerous then, obviously, for both employers and employees. So it's something to have a think about there with the default provisions. And like I said at the start, it's probably worthwhile having a read through the legislation, having a read through the ACAS guidance, because that gives you a bit more of a more understanding of the legislation rather than reading it directly. Right, and then just finally, this is just more sort of steps for employers. So the best outcome really is that as soon as somebody advises you that they are expecting a baby, or the partner's expecting a baby, discuss the leave intentions. Don't be frightened. This is a new concept. It's a new concept to everybody. So sit down with them, just talk to them about it. Probably most people may be aware of this now because it's all over the news and everything like that. And have an early conversation with them early on about what they want to do, and it may be that you can sort it out early on and everybody knows what's going on. So don't be afraid to speak to them. It is the employee's responsibility to check eligibility for shared parental leave. So it is up to the employee to check whether they are, and if they are, they have to do that notification process that we talked about. And then employers have to grant shared parental leave based on the information and declarations provided all the full information is being given and it's all correct. And we talked at the start about having a shared parental leave policy, and I know a couple of you mentioned you have had some requests and are looking at doing this. And I do think that would be best practice to have one in place so everybody knows what's going on and what process will be followed. And under that policy, you can include things like statements advising that all notices for continuous leave will be accepted, and that all requests for discontinuous leave will be considered, and maybe set out what process you'll follow on that. Also confirm how employees should inform their employer of their entitlement to shared parental leave and what information must be given, so it's very clear. and then time limits for dealing with a notice to book shared parental leave and how you'll deal with that. So that's quite key. The other things I just wanted to quickly mention, which is worthwhile knowing, is annual leave. Just like maternity, adoption, and paternity leave, just like what happens with them, employees will continue to accrue holiday. The other thing is split days, so shared parental in touch days, so a bit like keeping in touch days for maternity leave. These do exist. There's 20 of them under shared parental leave, and this just gives, obviously, the employee the chance to come in for team meetings or come into work without bringing the shared parental leave to an end. So it works the same way as, keeping in touch days for maternity leave. So that's something to bear in mind. And also, during shared parental leave, if you do have any employees off, after April on this, don't be concerned about don't be worried about keeping in touch with them. You can have reasonable contact with your employees during that period, and particularly you should be doing, because if there's any changes that affect them at work, they need to know. They need to be kept up to date with team meetings and any other news that's going on. So you should really be keeping them up to date. So don't worry about that you can't contact them, because you can. It's just got to be reasonable. And then just finally, I just thought it might be worthwhile mentioning employees returning to work after shared parental leave. So after they've taken shared parental leave, what are they entitled to? So they're entitled to return to the same job if their combined leave, which comprises maternity, paternity or adoption, and shared parental leave, totals 26 weeks. So where it's 26 weeks in total, they should be allowed to return to the same job. But where the number of weeks exceeds 26, then they should, where possible, return to the same job unless it's not reasonably practicable to do so. Then they must be offered a suitable and appropriate job as an alternative with the same terms and pay. So that's just a very, very quick overview, and I know it's a lot more in-depth and a lot more detailed than that, so I've tried to keep it to the salient points there. I know there's quite a few questions coming through, and I'll try and answer what I can now. I mean, what I'll say is my details will come up on the final slide, so if there's anything you're unsure of or anything that I haven't answered during this sort of chat, please feel free to get in touch with me. My email's on there, I'm on Twitter, I'm on LinkedIn, link in with me, drop me an email, drop me a note, if there is a question. I'll also have a copy of these questions as well, I understand, so if I haven't answered any, I will get back to you. But like I say, if you want to get in touch with me as well, great, I'm always happy to hear from people. So let me just have a look through some of these.
Discussion here about 20 split days for which employees are shared.
Yeah, the thing is a bit of confusion about that, because I did read a while ago that they were shared, but then I'm not sure now whether it's each parent. So that's something I do need to just clarify. So what I'll do is I'll take a note of who's asking the questions, and when I get the clarification on that, I will drop you a note, because I've got your emails and your details, so I can drop you a note about that. So that's fine.
There's quite a lot of questions. I don't know. There's so many questions. I don't know which ones you want to pick out.
Yeah, just give me a moment. I'll have a look and see what questions. I've got time for a couple of questions. So I've got Janet saying, can you speak to the other employer for the partner to check the information is correct? I think you're going to have to. I mean, I think, unfortunately, this is going to prove to be a bit of an administrative nightmare for employers, and I do feel for employers, because it is going to be, the administrative process is going to cause a bit of a backlog here, and I think you will have to speak to the other side. People will have to have a bit more of an open forum and be able to talk to one another, just to make sure that everything is right and there's not any issues. So I can't see that being a problem. So I've got, if a discontinuous shared parental leave request is turned down or ignored and become continuous, does the continuous period equate to the total number of weeks requested? That's a really interesting one, because I mean, what I understood from the legislation is if it's ignored and it's not withdrawn by the employee, automatically defaults to a period of continuous leave in a single block. So yes, I think probably what it would do is be a single block of the total number of weeks requested, I believe, is what will happen, which obviously isn't probably ideal for anybody there. And I think that this is the important thing with the default provisions, and this is where I think the most problems are going to arise, is that if employers simply aren't responding to the request on discontinuous leave, or they are responding and they unfortunately cannot accommodate it, if they don't make the employee aware that if they don't withdraw their request, it will default to a continuous leave. So I think it's something to really get your mind around. And I think probably what would be worthwhile alongside having your policy in place is actually having some template letters, and template letters about responding to continuous leave, responding to discontinuous leave, inviting to meetings, outcome letters. Have all these precedent letters in place covering absolutely everything now, so then when you do get the request in, you can simply ping them off, as and when you need to. And I think if you sort of get the admin side sorted out as much as you can, it should help you going forward. Yeah, the shared parental leave in touch days, like I say, I will let you know. I believe it is 20 each. I mean, like I say, ages ago the guidance seemed to be a bit different, and I will just double check that, and I will let you know, Vicky. Not a problem.
Okay. We've got a lot of people saying they want to be included on the Q&As all together. So I've got two choices here. We can either go back and finish the questions if you want for the next 15 minutes, those people that want to stay, or we can set an email up. Or should we just do the email?
Yeah, sorry about that, guys. We've got quite a lot of questions still coming through, and people would like to be involved in the Q&As if it's available to you all. So what I'll do, because I'm conscious obviously of the time and conscious of everybody else's time obviously as well, not just mine and Liz's, everybody's time, is if the questions that I haven't answered, obviously I'll have a list of them, and what we can do is I can just do a group email. So I can do this is the question, this is the answer type email, and just send it out to everybody, so you'll all be copied in, and then obviously that should hopefully answer any other questions that anybody has. So I'll do that. That's not a problem. Yeah. So Liz has just typed in to say if you've got any more questions, just start typing them now. Like I say, if you haven't got time right now to type it because you've got to rush off, just drop me an email, either me or Liz, an email with your questions, and we can sort of add it to the list, and then I can deal with them. It's not a problem. We'll deal with them. That's fine. And then everybody can have a go. Yeah, so that's it. Well, thanks ever so much for tuning in, and I look forward to hearing from you again. Thank you.
Wow, thank you, Caroline. That is a lot of questions, a lot of information. And as Caroline said, we'll send an email through with all the answers on there, and possibly maybe put a document together, maybe some frequently asked questions, and publish that as well. So just watch this space. We'll be in touch. Tomorrow we've got a double whammy this week. We've got predictions and resolutions for 2015. This is a CIPD joint webinar that we're running, and Michael Millwood will be presenting that. That looks to be quite an interesting one at that. So keep those questions rolling in. I'm going to keep the webinar line open just for a little bit longer whilst you do that, but I'm sure you probably don't want to listen to my dulcet tones, so off we go.